SJC-11820, Commonwealth v. Peter Bruneau.
Good morning, Ms. Jacobstein.
Good morning, Your Honors. Rebecca Jacobstein for Peter Bruneau. Mr. Bruneau was found not guilty by reason of mental illness, and his appeal presents two issues. The first being, does he even have a right to appeal, and under what statute? And if he does have a right to appeal, whether the evidence was sufficient to support the underlying finding of guilt. So I want to start with...
Well, the Commonwealth basically concedes that he has a right to appeal.
Yes, the Commonwealth does, and really now the argument is just about where that right to appeal stems from. And
so what's wrong with 211.3? Why isn't this? I mean, why doesn't one analogize this in that regard to appeals when somebody has a hung jury, and then there's an issue about whether there was sufficient evidence? So there's a double jeopardy issue that a defendant raises before a new trial. That comes up under 211.3. It gets reviewed. I mean, why isn't that adequate?
For Mr. Bruneau, certainly, as long as he's up here, it's adequate to him. But because 211.3 is only for extraordinary cases,
yes, but I'm suggesting to you that this kind of, I mean, it seems to me analogous to that, where people don't say, oh, this isn't extraordinary, therefore I'm not even going to think about it. I mean...
If in every case the person was going to get their right to appeal, then it really would not matter whether it's under 211.3 or under 278.28.
Well, let's think about it this way. Let's assume the basis of the appeal was not the sufficiency of the evidence, but a motion to suppress, which had been denied, and your claim is it should have been allowed. If it had been allowed, there would not have been sufficient evidence. So the NGI, you want to appeal it, but essentially you want to appeal it to have this evidence excluded, and maybe for a new trial, right?
Yes, Your Honor.
But would that be a 211.3? That doesn't really fit the double jeopardy kind of analogy that Justice Botsford was just speaking of.
Well, I think that the Commonwealth's argument, if I'm correct, is that in cases where you are raising sufficiency arguments, you can come under 211.3, and I don't think that they're necessarily conceding if you're not raising a sufficiency argument.
Well, if you're not raising a sufficiency argument, can you get here at all?
Well, that's why my argument is that you should be able to get here under 278.28, because that, so 278.28 says a defendant who is aggrieved by a judgment in a criminal proceeding may appeal. And
I don't want to torture you, but let's assume you were to win on a motion to suppress argument and the case goes back for a new trial, can the Commonwealth, can you be tried on the question of guilt? Or is it just NGI and not guilty? In other words, a new trial, does it start from scratch? And so you could actually be convicted of the underlying crime itself.
If you were only contesting
motion to suppress,
right.
Your argument was the motion to suppress should have been allowed.
Right, so you should not have been found NGRI at all, you should have just been found not guilty.
Right.
Well, or at least there's an argument that you would have been found not guilty. I mean...
Right, would have been found not guilty.
Well, if you are appealing, then you need to understand that that's what's going to happen. If that is not what you want to happen and you're okay with the NGRI...
So there would be a new trial and any verdict would be available.
Right. That's what I would think would happen under 278.28, is that you're opening yourself up there.
Okay.
So double jeopardy would not kick in as to the not guilty part of the NGI?
Well, because you've been found guilty of the underlying elements. And then it was just, were you criminally responsible for them? But you have to find all the elements first. And if you don't meet all the elements, then you've technically been found guilty, sort of. You know, it's like, first you have to meet all these elements.
I think you'd be arguing the other side of this if this were to come before us.
Me, I know it.
It's not this. Fortunately, it's not this case.
But you're arguing only sufficiency, so the issue is not raised. You don't have that risk in practice here.
Right, and that is why we are only raising this very one issue.
Okay, well, regardless of whether it's 211.3 or 278, Section 28, this seems to be a tough argument on sufficiency here, given all the evidence before the Commonwealth rested.
Well, the evidence is really consciousness of guilt and opportunity. Mr. Bruneau had a key to the apartment. He was found in the apartment. So he had an opportunity because Mr. Bruneau did not contest that the crime occurred in the apartment. But pretty much everything else stems from is consciousness of guilt evidence, and opportunity plus consciousness of guilt. I would say that the strongest evidence against Mr. Bruneau is the fact that he bought a chain that one could reasonably infer was the chain that was found with the body.
Just a couple of days.
6 days later.
5 or 6 days
yeah,
later.
he bought it on the 31st of August, and his body was found September 5th.
And this was a wellness check because of what?
He wasn't at work.
Showing up at work.
The
So he'd
victim.
been gone.
The victim was not at
You're
work.
right. So
He said it was Tuesday, so that would have been 2 days after the purchases, roughly.
He said he hadn't seen him since Tuesday. The evidence was someone had seen him on the 1st. So he bought it the 31st. The victim was last seen on the 1st, and the body was found on the 5th. So in that time frame. But while this would be it's a reasonable inference, it's a possible inference, but it's not the only inference, and it's at this point it's really just speculative. I mean, he has the opportunity, and he gives inconsistent statements, but that's it. I just want to point out to the court about the equivocal nature of the I got stabbed versus I got stabbed too, which it would be a damaging statement to say I got stabbed too, even though he wasn't stabbed, but because there would be an inference there that he knew that somebody else had been stabbed, but the police officer didn't testify to that. The police officer didn't know which one he said, and if the police officer doesn't know, the judge can't know either.
Were the stains in the house plainly blood stains?
some of them were, yes?
They were reddish-brown stains, and they tested them.
Well, I know they were tested and found to be blood, but I mean, is this somebody who basically is residing in a house where there's blood stains all throughout? And
Well, there was some, as I understood it, when the police first got there was a pool of blood still in some piece of furniture.
It was saturated to the I think a chair in the living room.
And the nephew had never seen that there before.
No. There was testimony that this man kept his house very clean.
Were there any incriminatory statements that the defendant had made to a psychiatrist or psychologist that came into evidence that might have contributed to the sufficiency of the findings?
None of them came in prior to the arresting of the Commonwealth's case.
Okay.
They all came in afterwards. So we're only looking up it to that point. So no.
No, I didn't see Commonwealth versus Curtis cited in your brief.
It was in my reply.
Is that because Ms. Montori found it?
Yes, I am very grateful.
It's an old case.
It is an old case.
1945.
So, no, it's not meant to criticize you as much to commend Ms. Montori in the highest standard to be presenting a case adverse to her position where it was not otherwise cited by you. So it was not to criticize you, but to recognize Ms. Montori acting in the highest tradition of the prosecutorial bar. So I guess with regard to Section 28 versus Section 3, I mean, one difference, of course, is if it's Section 3, we do it.
Yes, they would all be here.
And with regard to the definition of judgment, and I'll be asking Ms. Montori in a moment, was there any indication that there was a contemplation that a judgment may include, generally judgment means conviction and sentence.
Or it could mean acquittal.
Judgment
of acquittal.
But of course, conviction and sentence is, generally we associate conviction with sentencing, and so of course it makes sense to say it's not done till after sentencing. Does it not make sense to say that this is like an acquittal? It's a form of acquittal. It's an alternative to to an acquittal and therefore should be treated as such in that regard?
This court has in at least in statements said that it's similar to an acquittal, but I think that it's really, had he been discharged, that argument is possible. But given what happens to you when you're committed under Section 123, Chapter 123, Section 16, versus if you had otherwise been committed, I think that a commitment is akin to a sentence. He is being held in a Department of Corrections institution pursuant to a court order, and this is a significant deprivation of his liberty. Section 16, and this goes both to whether it's a final judgment because it's done, and there's cases that say, well, if there's a stigma just to a conviction, I think there's a stigma with finding of not guilty by reason of mental illness. But besides that, what happens to you is like a sentence. He is being held, and he can't get out. He can't get out from under Bridgewater without a hearing from where the Commonwealth has to be notified, and they get a chance to be heard. And
may refresh my recollection though. Is he being held by further order of the court, or is the law require that he be held once he's found not guilty by reason of insanity?
I think under 16, once he's found not guilty by reason of mental illness, they may have to make a certain finding that then he needs to be
order. The
right.
Judge may order.
So he goes under.
Okay.
And then they start the whole commitment
Right.
process.
But it's a civil commitment process, isn't it?
Yes.
In the first commitment is 1 year, and all the subsequent commitments are for 6 months.
I think it's the opposite of that. I think it's for 6 months, but 1 year. But
And then all the others are 1 year?
yeah.
Okay.
Yeah. But in any event, if he were to go on the same commitment, if they were going to use these same facts without the NGRI, they wouldn't be able to send him to Bridgewater at all, and he wouldn't be subject to some of the harsher.
But it's not only people who have been found NGI on a murder charge who go to Bridgewater. There's an additional finding of dangerousness?
Yes, you have to. Well, right. They have to make that you.
So he could get
serious
ratcheted
harm
down
there.
conceivably from Bridgewater to some other state mental hospital
For the first commitment.
for the subsequent commitments.
Right. Eventually, he can be moved.
Is he at Bridgewater now?
Yes, he is at Bridgewater now, but he can't be moved without. It's just the clinicians and his treatment team just can't say, "Hey, this guy's ready to go." He still has to, because he's in under Section 16. He has to jump through hoops with the hearings and with the DAs.
Didn't he have his hearing?
He's never had a hearing to be reduced. I don't believe he has had a subsequent hearing, where his clinicians did not feel that he was ready to be stepped down. But when he is, because his conviction is, even though this case is old, his conviction is somewhat recent because he was incompetent for so long.
All right, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Jane Montori on behalf of the Commonwealth in this case. And while the Commonwealth agrees that the defendant should have a right to appeal, under the statute 278, Section 28 as written, and as this Court has interpreted it, the Commonwealth believes that an appeal in this case does not fall under this statute. Instead, it would fall under General Law, Chapter 211, Section 3.
And what makes that different, sufficiently different in your mind? I mean, why? Why not?
Well, because the definition of judgment has consistently been.
No, let's put that aside. I'm sorry, I didn't mean to.
Okay.
Let's just talk practicality. You say, we agree, let us say, that there is a right to appeal, at least the sufficiency of the evidence. As a practical matter, why shouldn't this proceed under Section 28?
Well, because then I think you come into a distortion of the language of the statute.
He's
And
agreed.
practically speaking, frankly, I don't think this is going to come up very often.
Probably not.
Because in most cases where a defendant asserts a lack of criminal responsibility, there's no question that he or she committed the crime.
And how often is an NGI the outcome anyway?
Right.
Well, it was likely here, or he had a much better chance here because he went jury waived, and
Yeah.
that's a pretty good signal to the defense bar.
Right, because all of the experts in this case found that he lacked criminal responsibility, so the Commonwealth reduced the charge to second-degree murder, and the defendant waived a jury.
I guess picking up on Justice Cordy's question, I mean, with regard to other deprivations of liberty for civil commitment, you go to the appeals court, at least initially. Why should this deprivation of liberty be different from all other deprivation of liberties?
I think because of the court's prior definitions of judgment includes a guilty verdict at least and a sentence. And then there are the court's
But
decisions.
an acquittal would be a judgment.
An acquittal as well.
So, I mean,
But
I understand that they may not have anticipated in drafting that statute that there could be an appeal of an acquittal, but here there can be. So why should we not simply say a judgment is an acquittal or an acquittal is an NGI as well as an NG?
Well, you can certainly do that, but I don't know what other consequences there might be. There are the cases that discuss the SDP statute. If somebody's civilly committed, this court has held and the appeals court has followed that if a person serves a sentence and then goes from the sentence to a civil commitment under Chapter 123, that person is no longer serving a sentence, is no longer a prisoner for so the Commonwealth could not file a petition for SDP while after that person has served the sentence and has moved into the civil commitment sphere, even though that person's liberty is still constrained. So I think that there might be consequences of bringing this under the definition of 278.
How does what you just said, I'm missing that. How does what you just said about the consequences of, I mean, if somebody moves from serving a sentence to a civil commitment, how does that figure into the interpretation of Section 28?
Well, you're no longer a prisoner. You're no longer serving a sentence. And again, those cases cite what judgment is.
Oh, okay.
Well, if after the NGI, the defendant files an appeal within 30 days, and in the meantime, the commitment process proceeds, and the psychiatrists where he's being evaluated come back and say he's no longer mentally ill. So that there's a hearing before the judge, and the judge releases the person, having been found not guilty by reason of insanity and no longer mentally ill and a risk of serious harm to others. He's now walking the streets. Can the defendant pursue that appeal?
If the court decides that an appeal can lie under Section 28, I think that person could.
Otherwise, could he come up under 211.3?
I suppose he could, but then it might be denied. It would be denied because there's no deprivation of liberty. I mean, that can happen in any case. When a person is found not guilty by reason of insanity, there's an observation period, and at that point, the institution can say he's no longer mentally ill and he can walk.
So unless we were to say that there is an appeal, there is a right of appeal under Chapter 278, there would be nothing. There might be nothing, no means to challenge. For someone who was released, there may be no means to challenge the sufficiency of the evidence or the correctness of a ruling or any issue of law.
No definite means to challenge.
No definite.
There's always the possibility of a 211(3), but that could be denied.
Okay.
As to the sufficiency of the evidence in this case, this was a circumstantial case, but as the court is well aware, circumstantial evidence is sufficient to meet the requirements of a required finding of not guilty. On August 31st of 2008, the defendant went to Home Depot and bought a chain, a cinder block, gloves, and a hatchet.
Was there any evidence connecting the any blood or anything on the hatchet that was found, outside the closet in that second bedroom? I understand it was the same hatchet that was bought at Home Depot, but connected to the
No.
wounds or any. I thought that there was something other than just stab wounds.
There were injuries, blunt force injuries to the head. There was no forensic evidence
Connecting
the hatchet to the injuries. The defendant was last seen the next day, which was September 1st, Labor Day. He didn't appear for work for several days, and a well-being check was conducted. The police knocked on the front door of the apartment, the back door. The defendant didn't answer. The firefighter went in through a window, and blood was seen in the apartment. The victim's nephew said he had never seen blood before. There was blood on a rug, and when officers saw that, they asked the defendant if he were injured. And I would suggest, in the light most favorable to the Commonwealth, the defendant said, "I was stabbed too." At that point, these were details that no one knew. No one knew that the victim was dead. No one knew that the victim had been stabbed, because the body was found later that day on the site of Interstate 91 in Vermont, wrapped in the same chain that the defendant had purchased at Home Depot.
Do you agree with your sister that if I understood her correctly, that if there were an appeal that was successful after an NGI on grounds other than the sufficiency of the evidence, for instance, a suppression motion or perhaps a prosecutor's closing argument, admission of certain evidence, something, and if it were successful, that the Commonwealth could retry on a murder charge?
I'm not sure that the Commonwealth could retry it.
Yeah.
I mean, you can't try a not guilty, retry a not guilty. If the evidence is insufficient, that's the end of the case.
Yeah. No. Other than insufficiency.
Oh, I'm sorry.
Tricky question.
It is a tricky question. I suppose
I mean, if
I would argue we can, but
Yeah.
whether you would agree, I'm not so sure. And I hadn't come across that at all in any of my research, because, I mean, obviously the defense is going to argue he was not guilty, and as far as whether his mental status has changed, that's another question, and I'm sorry, I don't know the answer to that.
Okay, thank you.
But thank you very much, and I would ask that the conviction be affirmed.
We'll take a morning break.
All right.